Pathfinder Retirement welcomes you to our informative video, breakdowns of your Vanilla's estate planning documents. Here are the key points from the Jordan Revocable Trust document. 1. Trust creation and purpose. The document establishes a revocable trust for estate planning purposes. It is designed to manage and distribute assets efficiently, avoiding probate and providing for beneficiaries. Second trustee and successor trustee. Names the initial trustee, likely the grantor, Jordan's spouse. Identifies successor trustees who will manage the trust if the original trustee becomes incapacitated or passes away. Defines the powers and responsibilities of the trustee, including investment decisions, asset management, and distributions. 3. Trust assets and management. Lists the assets that are included in the trust, e.g., real estate, bank accounts, investments. Provides guidelines on how the trustee should manage these assets, including any restrictions or requirements for asset preservation. 4th, beneficiaries and distributions. Names the individuals or entities that will receive assets from the trust. Specifies conditions for distributions, such as age-based milestones, education expenses, or discretionary distributions based on need. May include provisions for the surviving spouse, children, or other heirs. 5th, revocability and amendments. Confirms that the trust is revocable, meaning the grantor can change or dissolve it during their lifetime. Provides a process for amending or revoking the trust, usually requiring written notice or formal documentation. 6th, incapacity or death of grantor. Describes what happens to the trust if the grantor becomes incapacitated, e.g., due to illness or cognitive decline. Provides instructions for successor trustees to take over management. Outlines how assets should be distributed upon the grantor's death, often avoiding probate. 7. Taxes and expenses. Addresses tax implications of the trust, including income and estate taxes. Assigns responsibility for paying trust-related expenses, such as legal fees, trustee compensation, and maintenance costs for trust assets. 8. Governing law. Specifies which state's laws will govern the trust's interpretation and administration. This can impact tax treatment, legal disputes, and trustee responsibilities. 9. Special provisions. Includes any unique conditions or restrictions, such as spendthrift clauses to protect beneficiaries from creditors, stipulations on how funds can be used, e.g., education, healthcare, charitable donations, provisions for special needs, beneficiaries to ensure they do not lose government benefits. Here's a breakdown of the certification of trust, trust establishment and existence. The trust is officially executed and currently in existence. It is a revocable trust, meaning the settlor, creator, retains the right to modify or terminate it. Roles and authority. The settlor and trustee are the same person. The trustee has full authority to manage the trust. If multiple trustees are involved, 2 trustees must act unanimously. More than 2 trustees must act by majority vote. Trustees can delegate powers under certain conditions. Beneficiaries. During the settlor's lifetime, they are the primary beneficiary of the trust. Legal and tax considerations. The trust uses the settlor's Social Security number as its taxpayer identification number. The official title for property ownership follows the format: trust name, dated execution date. Trustee name, trustee. The trust remains valid and unmodified in a way that contradicts this certification. Third-party reliance. External parties, e.g., banks, financial institutions, can rely on this certification as proof of the trust's existence. They are not required to verify the full trust document or question the trustee's authority. Notarization requirement. The document must be signed and notarized to be legally valid. A notary public confirms the identity of the trustee and applies an official seal. This certification serves as a summary document to verify the trust's existence and the trustee's authority without disclosing the full trust details. Here's a detailed summary of the Jordan pour-over will, testator and intent. The will is created by Jordan, intending for their assets to be transferred into a trust upon passing. Executor and administration. A specific person, likely named in the will, is designated as the executor or personal representative, responsible for handling the estate, paying debts, and distributing assets according to the will's instructions. Pour-over provision. Instead of distributing assets directly to individuals, this will transfers all remaining estate assets into a pre-existing trust. The trust then determines how the assets are managed and distributed. Beneficiaries, likely the spouse and potentially others, is named as a primary beneficiary. The details of distribution may be outlined in the trust rather than the will itself. Guardianship for minors, if applicable. If Jordan has minor children, the will might specify who should serve as their legal guardian. Debts and expenses. The document may outline how outstanding debts, taxes, and administrative expenses should be handled before assets are transferred to the trust. Final arrangements. The will might contain preferences for burial, cremation, or funeral arrangements. Revocation of previous wills. Typically, this type of will revokes any previous wills or codicils made by the testator. Here's a breakdown of the Financial Power of Attorney, POA document. 1. Purpose and scope. Grants authority to an agent to manage financial matters on behalf of the principal. The powers granted can be broad, allowing control over various financial and legal matters. 2. Powers granted. Principal must select. The principal can authorize the agent to handle real estate transactions, buying, selling, leasing, or managing properties, personal property transactions, managing goods, valuables, and possessions, banking transactions, accessing accounts, making deposits, withdrawals, handling loans, business operations, managing a business or financial interests, insurance matters, handling claims, modifying policies, estate transactions, managing estate-related affairs, retirement plans, managing retirement benefits, claims and litigation, handling lawsuits, settlements, government benefits, managing Social Security, military benefits, etc. Records and reports, accessing financial records, tax filings, voter registration, and absentee ballots, managing election-related matters, other matters, any additional specified powers. Third, special authority optional and requires explicit selection. Trusts, creating, modifying, or revoking trusts. Gifting authority, making gifts within legal limits. Beneficiary designation, changing financial or insurance beneficiaries. Transfer on death deeds, modifying property transfer upon death. Survivorship rights, altering shared asset rights. Delegation of power, allowing the agent to assign their authority. Retirement benefits, waivers, waiving certain annuity rights. Fiduciary powers, exercising powers on behalf of the principal. Electronic communications, accessing digital messages under federal law. Fourth, agent execution requirements. The principal can choose whether multiple agents, if appointed, must act jointly or individually. 5. Effective date options. The POA can take effect immediately upon signing or only upon the principal's incapacity. If effective upon signing, the principal can decide whether incapacity revokes it. 6. Revocation and termination. The POA remains valid until the principal revokes it by executing a new POA. The specified time period, if any, expires. The principal becomes incapacitated, if stated in the document. 7. Legal protections and liabilities. Third parties, e.g., banks, financial institutions, relying on the POA in good faith, are protected from liability. Refusal to accept a valid POA may result in civil penalties, damages, and legal fees. 8. Notarization requirements. The document must be signed and notarized to be legally binding. If someone signs on behalf of the principal, that person cannot be an agent and must also have their signature notarized. Key points from the Jordan Letter of Wishes. Purpose: a non-binding document providing guidance to the trustee on handling trust assets in alignment with the settlers, Tony Jordan's, values and intentions. Primary intentions: ensure beneficiaries' financial security while promoting self-sufficiency. Avoid excessive distributions that may dilute wealth for future generations. Encourage responsible financial behavior and personal growth. Values and principles: support basic needs such as education, healthcare, and living expenses. Promote financial responsibility and discourage extravagance. Encourage entrepreneurial and educational pursuits. Allow for charitable giving if beneficiaries' needs are met. Trust distributions, directed towards family, multiple generations, or named beneficiaries. Covers essential living expenses, education, and healthcare. Extraordinary events. Trustee is granted discretion in cases of unforeseen hardships like natural disasters, health crises, or divorce. Minor children. Trustee should support a guardian in caring for minor children until they reach maturity. Distribution guidelines. Annual or staged distributions, with potential increases at certain ages. Trusted advisors. Trustee encouraged to seek guidance from legal, financial, and tax professionals. Final notes. The letter is subordinate to the trust agreement in case of inconsistencies. Only the most recent letter should be considered valid. Here are the key points from the Healthcare Power of Attorney, POA. Agent appointment. Primary agent: a designated individual to make healthcare decisions. Alternate agent: a backup agent if the primary is unavailable. Agent's authority: authorized to make all healthcare decisions, including consenting to or withdrawing treatment, hospitalization, and surgery. Can choose and transfer medical providers as needed. Effective date: authority takes effect immediately and continues indefinitely unless revoked. Life-prolonging treatment: options to accept or refuse life-sustaining treatment in cases of terminal or permanently unconscious conditions. Not selected in this copy. Pain management requires initials to authorize pain relief medication and treatment. HIPAA authorization: the agent has full access to medical records and health information. Revocation and amendments: supersedes all prior healthcare directives. Can be revoked or modified anytime while competent. Effect of divorce: if the agent is a spouse, their authority is automatically revoked upon divorce. Liability: the individual or their estate is responsible for medical expenses, not the agent personally. Copies are valid. A copy holds the same legal effect as the original. Witness and notary requirements: requires 2 witnesses who are not agents, relatives, or heirs. Must be notarized for legal validity. Here's a summary of the Jordan Family Estate Report. 1. Overview. The report provides a full financial and legal review of the Jordan family estate, analyzing assets, liabilities, and future management strategies. It aims to ensure financial stability, legal compliance, and long-term growth while preserving family wealth across generations. Second, financial summary. Total estate value: a breakdown of the estate's net worth considering both tangible and intangible assets. Revenue streams: income sources include rental properties, investment dividends, and business profits. Expenses and liabilities: covers mortgage payments, maintenance costs, taxes, insurance, and legal fees. Investment performance: evaluates the return on investment, ROI, of stocks, bonds, and business ventures. Debt analysis: identifies any loans or outstanding liabilities affecting liquidity. Third, property and asset portfolio. Real estate holdings: detailed valuation of residential, commercial, and undeveloped land properties. Investment portfolio: breakdown of stocks, bonds, private equity, and business ownership stakes, liquid assets, overview of cash reserves, bank accounts, and other easily accessible funds, business interests, ownership stakes in family-run businesses or external partnerships. 4. Legal and estate planning. Wills and trusts ensures proper inheritance distribution among heirs. Legal compliance aligns with tax laws, estate regulations, and financial reporting requirements. Ongoing legal matters. Any disputes, litigations, or unresolved property claims are noted. Succession plan. Strategies for transferring control of businesses and assets to the next generation. 5. Future planning and recommendations. Wealth preservation. Recommendations for diversification, reinvestment, and risk management. Tax optimization. Strategies to reduce tax burdens on inheritance and capital gains. Growth strategies. Identifies opportunities in real estate expansion, new investments, or restructuring businesses. Family governance ensures smooth estate management and decision-making for future generations.